It's important to understand some of the statutory and regulatory laws concerning California's so-called underground regulations. Now, the California Office of Administrative Law, or OAL, is charged with ensuring that executive branch agencies and departments, when they adopt their regulations, are quote unquote clear, necessary, legally valid, and available to the public. OAL, therefore, is responsible for reviewing proposed regulations by California's more than 200 state agencies, departments, boards, commissions, and bureaus that have some level of rulemaking authority. The formal rulemaking process is established by the APA, the Administrative Procedure Act, which is found in the state's government code. And among its many provisions, the APA sets forth the criteria by which OAL must review all of these proposed regulations, basically to ensure their compliance with the APA procedural requirements. And OAL reviews regular and emergency rulemaking projects, as well as considering any challenged so-called underground regulations. On the OAL website, which is www.oal.ca.gov, reviewers can track the list of rulemaking actions submitted to OAL for review, both regular and emergency rulemaking. And this list is actually updated daily per the OAL. Their website also contains a listing of underground regulation petitions that are currently under review by OAL. What are regulations governing the review of underground regulations by OAL? Well, the role of OAL is specified in the California Code of Regulations, the CCR, in Title I, Division 1, Chapter 2. And Chapter 2 is naturally titled Underground Regulations. In Section 250A of Title I, that's the regulations, it provides the following definition. Underground regulation means any guideline, criterion, bulletin, manual, instruction, order, standard of general application, or other rule, including a rule governing a state agency procedure that is a regulation as defined in Section 11342.600 of the Government Code, but has not been adopted as a regulation and filed with the Secretary of State pursuant to the APA, and is not subject to an express statutory exemption from adoption pursuant to the APA. So that's a mouthful, but that is what an underground regulation is. Basically, it is, for practical purposes, a regulation, but has not been formally adopted as one. In CCR Section 260, the submission of underground regulation petitions is covered. And Section 270 deals with the OAL's review of these petitions. Section 280 describes the suspension of underground regulation actions. In terms of underground regulations, OAL is charged with reviewing any of these challenge regulatory agency actions by way of a written petition that's filed with OAL. Now, according to OAL, if a state agency issues, utilizes, enforces, or attempts to enforce a rule without following the APA when it is required to do so, then the rule is called an underground regulation. And as you might expect, state agencies are prohibited from enforcing or utilizing any underground regulations. Now, if an individual or an organization or other entity believes a state agency or department has issued an alleged underground regulation, that issuance can be challenged by filing a written petition with OAL. And as a part of the written petition submitted to OAL, the petitioner has to provide the written petition and all attachments to the challenged agency prior to or at the same time that it submits the petition to OAL. The petition is also required to contain certain information. Naturally, the petitioner's contact information and the name of the challenged agency and a description of the challenge rule, also a photocopy of it, a description of the actions that the challenge agency has issued or used to enforce the challenge rule, the legal basis for concluding it's not a regulation, or that it is a regulation that was not properly adopted, information that the petition raises an issue of considerable public importance, and some other specific information that's found in the regulations in Title I. In CCR Title I, Section 270, this concerns the review of petitions regarding underground regulations. And basically, it says that when OAL receives a written petition, that OAL has to determine if the petition is complete. They have 60 calendar days to do so. Now, if the petition is deemed to be incomplete, then OAL has to notify the petitioner in writing what is missing from their written petition. And then OAL will begin a new review period when the petition is complete. Now, after that review, OAL will either accept or decline to consider the written petition. And OAL informs the challenged agency that the petition is under review, and it offers to provide a copy of the petition. Within 60 days, OAL is required to determine whether or not to consider the petition on its merits, either in its entirety or in different parts. Now, while OAL has exclusive discretion to consider the written petition, factors that they consider in deciding whether or not to accept a petition must include the degree to which the petition raises an issue of considerable public importance, whether the issue raised by the petition is being considered by a court or other body, whether the challenge rule has been superseded, whether the challenge rule has been or has expired by its own terms, and any additional relevant information. If OAL declines to consider the petition, then OAL is required to immediately advise the petitioner and the challenged agency of that decision. OAL has to specifically indicate that the decision in no way reflects on the merits of the underlying issue presented in that petition. On the other hand, if OAL decides to consider the petition on its merits, then OAL is required to issue a summary disposition or issue a determination. Now, circumstances in which facts demonstrate that the challenge rule is not an underground regulation include the challenge rule is contained in a California statute, the challenge rule is contained in a regulation that has been adopted pursuant to the APA, or the challenge rule is statutorily exempt from the rulemaking provisions of the APA. Now, if OAL issues what is called a summary disposition, then the written document states the basis for concluding that the challenge rule is not an underground regulation. Also, a summary disposition is filed with the Secretary of State, sent to the petitioner and the challenged agency, and this occurs within 60 calendar days following a receipt of the complete petition. And then OAL actually also publishes their summary disposition in the CRNR, the California Regulatory Notice Register. Now, if OAL, on the other hand, issues a determination, then OAL is required to notify the petitioner and the challenged agency of its decision and publish that petition in the next California Regulatory Notice Register. The purpose of that is to give notice to the public that comments on issues raised by the petition may now be submitted to OAL. And any public comments are required to be submitted within 30 calendar days from the date that it is published in the California Regulatory Notice Register. The challenged agency, as you might expect, can submit a response to the petition for OAL's consideration. However, no response may be considered by OAL unless the challenge agency provided a copy of its response to the petitioner at the same time they submitted it to the OAL. Now, any response by the challenged agency is required to be submitted to OAL within 45 calendar days after the petition has been published in the California Regulatory Notice Register. Thereafter, the petitioner can submit to OAL a reply to the challenged agency's response. That has to be done within 15 calendar days. Finally, within 120 calendar days, OAL is required to issue a determination regarding whether or not the challenged agency has issued, used, enforced, or attempted to enforce an improper or illegal underground regulation. Section 280 of the CCR, Title I, concerns the suspension of actions regarding underground regulations, and it provides that any action of OAL is to be suspended if prior to filing its determination with the Secretary of State, OAL receives a written certification from the challenged agency that it will no longer use, enforce, or attempt to enforce the challenge rule. In that case, OAL is required to file the petition and certification with the Secretary of State, as well as publish both the petition and the certification in the California Regulatory Notice Register. If OAL accepts the petition, remember OAL is going to issue that determination ultimately. According to OAL, this program where they review it is informally known as the Chapter 2 Unit, or CTU. And that's because the OAL regulations regarding underground regulations, again, are in the CCR Title 1, Chapter 2, so Chapter 2 Unit. And the OAL website provides information on underground regulations and specifically how to provide or how to submit your written petition challenging an alleged underground regulation. OAL's review of an alleged underground regulation is basically conducted, and it's limited to a three-step analysis. And that analysis by OAL is used to determine whether the alleged underground regulation in fact must be adopted as a regulation under the procedural requirements of the APA. So what's the three-step analysis? First, is the policy or procedure either a rule or a standard of general application, or is it a modification or supplement to a rule? Second, has the policy or procedure been adopted by the agency to implement, interpret, or make specific the law that they're enforcing or administering? If the answer to these first two questions is yes, then the challenge rule is a regulation. However, before that determination is complete, OAL has to review the final step of its three-step analysis. The third point is has the policy or procedure been expressly exempted by statute from the requirements of the APA? Now, if the answer to this final question is yes, then obviously the underground regulation didn't have to go through the APA process. However, if the answer to this third and final question is no, then the rule is in fact an underground regulation and it cannot be enforced or used by the agency or department. Instead, if they want to do so, they have to go through the formal rulemaking process, obviously pursuant to the APA. Readers should also, or listeners should also be aware of Government Code Section 11340.5 Subdivision E. This provides that if an interested person has already begun litigation that's challenging an underground regulation or an alleged one, a determination issued by OAL may not be considered by the court in that pending litigation. In other words, those challenging an alleged underground regulation should determine whether they want to pursue OAL review or whether they want to go directly to court to challenge it. So briefly, how have California courts viewed underground regulations? In terms of a definition, the courts have ruled that any regulation not properly adopted under the APA is labeled an underground regulation. And an OAL determination that a particular administrative guideline is an underground regulation is not binding on the courts, but it is entitled to some deference. Cases like Davenport versus Superior Court in 2012, an appellate court decision, People versus Medina in 2009, also an appeals court decision where review was denied by the California Supreme Court. Moreover, the courts have noted that an underground regulation is a regulation that a court may determine to be invalid because it was not adopted in substantial compliance with the procedures of the APA. Here you can check out a 2018 decision by the Court of Appeal, Fisher versus State Personnel Board. There are some exceptions to the underground regulation rule. For example, any agency advice or opinion letters that are not characterized as underground regulations that violate the APA, they can be considered when a court is considering the applicability, for example, of a wage order. This was determined by a California Court of Appeal decision in 2010 called United Parcel Service Wage and Hour Cases. So this is generally how California courts have viewed underground regulations. Obviously, there are both statutory but particularly regulatory provisions that you should be familiar with in dealing with alleged underground regulations.